And welcome everyone. Thank you for attending today's session on civilian casualties and partnered operations. Um, there's an old saying that the enemy of my enemy is my friend, and there is a somewhat newer saying that states don't have friends, they have interest. I think when you combine the two, you get a saying that is the enemy of my enemy is my interest. And I think this is an important distinction because it highlights the strong desire of states to leverage partners in fighting a common enemy while also acknowledging the interpersonal and transactional nature of the relationship. It recognizes that in partnered operations, the relationship in many situations is not is one that is shallow, fleeting, utilitarian, and that is typically not based on shared values, but rather on convenient necessity. So I want to spend a few minutes today discussing the risk of partnered operations it poses to civilians. We'll follow that by ways in which partnered operations can actually reduce the risk to civilians, and then conclude with some ways that the risk to harm can be reduced and the benefits can be enhanced. There are several reasons that partnered operations can lead to incidents of civilian harms. While there are sporadic incidents of IHL violations in what I'm going to use the term sophisticated militaries, so a coalition of sophisticated peers, such as something like the NATO coalition. These types of coalitions typically do not have systematic incidents of IHL violations. And then the few incidents they do have, they are usually investigated and steps are taken to document what happened and for accountability. Where we do see systematic IHL abuses in partnered operations, they tend to occur when a more sophisticated military is fighting with or supporting a less sophisticated fighting force. These could be sophisticated state militaries working with a less sophisticated state military or a sophisticated state military working with a non-state armed group. I think there are several factors that contribute to this issue, and I'm only going to discuss a few today. I'll start with the difference in weapons. For example, the risk of harm to civilians goes up when a state that has and is used to using more precise weapons fights with or supports a group that possesses less precise weapons. And certainly that increases if that partner is operating in areas where there's a high concentration of civilian population. There's also a difference in tactics and procedures. Even in partners using the same weapons, many sophisticated state militaries employ tactics and procedures that are designed to mitigate civilian harm. Procedures like the collateral damage estimate methodology can account for many variables that help mitigate harm risk to civilians. But even if this is shared with partners, this methodology is likely above the level of capability of some state militaries and certainly many non-state armed groups. Just example for those of you who aren't familiar with it, the collateral damage estimate methodology course in the US military is a week long in which many students who have at least a minimum high school education struggle to pass. For the next factor is a distinction difference in command and control. Many sophisticated militaries have strong centralized command and control structures, and the targeting decisions they have can reduce harm to civilian. I'm sorry, the targeting decisions that they are where there are high risks to civilians are generally made by officers that have several years of training, not just on the weapons, but also training on how to mitigate harm to civilians. In contrast, many non-state armed groups are led by people with little formal military training who may not understand the capabilities of the weapons they're using, may be operating with a level of autonomy that doesn't exist in state militaries. The next factor is a lack of understanding of each other's capability. And I think this lack of understanding is a two-way street. And it certainly is overestimating the capabilities on each side. The state government militaries may well overestimate the capabilities of a non-state armed group. And at the same time, that non-state armed group may overestimate the ability of a state military to act with precision. Both of these overestimates of the capabilities can lead to higher civilian harm. The next factor I want to discuss is the difference in cultural values. Well, the basic principles of IHL include the protection of civilians and limiting unnecessary suffering are really found in every culture of the world. There are differences. The IHL Roots of Restraint report does an excellent job in discussing this and the difference in the different types of groups and how the culture can impact them. One of the factors highlighted as a reason why the fighters show restraint on the battlefield is that they come from a culture that respects the rule of law, and more specifically IHL. If their community knows the law and expects their fighters to comply with it, compliance has a much higher rate than coming from a culture that doesn't. The next factor is a lack of training and education. Even if a group culturally might respect IHL, the fighters may lack the training on the rules and the guiding principles behind them. Additionally, they may lack the educational background to understand how to correctly use the weapons and the techniques supplied to them. Again, I think about the collateral damage methodology, collateral damage estimate methodology that may work well for an educated fighting force, but may be ill-suited for a partner uneducated fighting force. And the final factor on why I think the risk is higher, at least the final one I'm going to discuss today, is a willingness of a civilian, of a groups to accept civilian harm to advance their cause. And this may be the most critical factor that can cause harm to civilians to go up in partnered operations. If a person is willing to die for their cause, they're almost certainly willing to let civilians die for it or to kill civilians to advance their cause. And in fact, there are many groups that have deliberately harmed civilians as a way to advance their cause. And a state that partners with a group that has a known disregard for civilian life may well be complicit in the harm that that group causes to civilians. Knowing that in partnered operations where these factors exist, that civilian harm will be higher, the question that I think is important to ask is what are states' obligations related to their partners? The Common Article 1 of the Geneva Conventions from 1949, although just one sentence, 18 words, says a lot on the subject. It states that high contracting parties undertake to respect and ensure respect for the present convention in all circumstances. The 1952 commentaries discuss the meaning of this article, and the 2016 commentaries further elaborated on their meaning. Additionally, Additional Protocol 1 has a similar provision requiring high contracting parties to respect and ensure respect for the protocol in all circumstances. Well, it's clear that these articles require high contracting parties to comply with the conventions, and if applicable, the protocol. It's less clear concerning a state's obligation to the extent they must ensure compliance with their partners. While the discussions on how far a party's obligation under these articles extends to their partners is ongoing and should continue, I think it's safe to say that it is a far from settled issue. While a state's legal responsibility may hinge on the control it has over partnered operations, the standard for a state's moral obligation may be higher. Put another way, the degree that a state's own population and the international community holds it morally accountable may differ from the standard of legal accountability. Okay, before jumping right into how do we influence a partner's behavior, I want to take just a minute to discuss the positive aspects of partnered operations, because I think it's overlooked sometimes. It's always difficult to prove a negative, and paraphrase from Sherlock Holmes, maybe actually mangle what comes from Sherlock Holmes. Does anyone hear a dog that doesn't bark? So put it in IHL context. Does anyone notice when in a partner operation, the partners don't violate IHL? It's always difficult to measure the impact that a sophisticated state or sophisticated military may have on a less sophisticated partner. The behind the scenes insistence that the partner avoids civilian harm, the respect for IHL that is included in the training that may be provided, even to the level of modeling good behavior for the partners' forces to emulate, can all play a role in better behavior by partners and reduce the risk to civilians in partnered operations. This is one reason that I think that we need to use caution in emphasizing just the negative aspects of partnered operations. And in fact, the tools I'm about to discuss, it may be hard to measure their impact because it is, as they say, it's hard to determine if the dog didn't bark. But in IHL terms, we've got to determine if the violation didn't occur. To look at tools for influencing a partner's behavior, the Center for Civilians in Conflict, among others, I think has done an excellent job. Partners can vet the behavior of the groups before deciding to support it. And while groups, especially non-state armed groups, can change over time, if they demonstrate a lack of compliance at the front end, it's likely that they're not going to be suitable partners. The establishment of expectations up front through condition support is another major factor for getting compliance. Setting the expectations at the beginning of the relationship makes it very clear and provides additional leverage if a partner strays from the agreed upon conduct. Requiring the partner to conduct training or requiring them to accept training that can focus on reducing civilian harms is another way that partner operations can have a positive influence. Just keep in mind that it's sufficient training, what may be sufficient training for a high school educated fighter from a state military may not be suitable for a 17-year-old non-state armed group fighter who's never attended school or had any formal education. In these area, I think, well, I personally have great admiration for the work that Geneva Call does, as they design IHL training specifically for members of non-state armed groups that kind of emphasizes and plays upon the culture they're coming from and the background of these fighters. There's also the conduct of IHL shaping operations with potential partners. I think this is something that should be done by states as they look at partners they may want to operate with in the future. For this, I think the Defense Institute of International Legal Studies does a good job, but I do think the U.S. could do more in working with military exercises to ensure their partners in these joint exercises also build into the exercise itself compliance with IHL. I think the U.S. does it within their own, but I think we could do more in encouraging our partner nations to do it. The adoption of state laws, I think, can also play a good role, and I think the Leahy Law does this in the United States. While far from perfect, it does limit funds going to foreign units of foreign security forces if there's credible information that that unit has a gross human rights violation. And it also requires vetting, which I talked about earlier. So I think both of these factors should be included, and I don't want to minimize the impact that they can have. Certainly, it provides leverage both within the partnered force, but also leverage within the state's military who wants to continue to partner to know that they have to put more emphasis on behavior of their partner if they're going to continue these operations. And then increased transparency. This is probably one of who the partner is, what are partner operations. I think this is one of the more difficult ones because there are plenty of reasons that states want to keep things secret beyond covering up or shielding from IHL violations. For example, they may not want a conflict to expand by having their involvement noted by others, at least not openly noted, or they may lack domestic support for what they're doing, but they still want to influence the fighting where it is. So that transparency is always going to be an issue. And I think it's the more we can get, the more we'll be able to reduce the harm to civilians. So I think we know as a population of the world continues to grow and population centers continue to expand, that there are going to be more civilians that face risk at armed conflict. So I think it's important that we continue to seek ways to reduce civilian harm. I don't think partnered operations are going to go away. And I think that we're going to continue to need, there's going to be a continuing need for us to seek out methods and techniques to leverage the partnered operations that are going to go on. I am thankful I get the chance to talk to you for a few minutes today, and I am excited to hear what our panelists have to say next. So thank you. Ben, I'll turn it back over to you.
Thank you very much, Randy. I'm going to take over from now. My name is Anissa Belal. I'm a senior researcher and strategic advisor on international humanitarian law at the Geneva Academy of IHL and Human Rights. It's a pleasure to be here today and to moderate this panel on partner operation, which is indeed a crucial topic. As we know, there are multiple international operations that have been going on these past years. And I was very, very interested in hearing about Randy's remarks, especially with regard to armed non-state actors, which are often forgotten in the equation and how we talk about the respect of the law. To talk about this issue, we have a stellar panel with distinguished speakers, which I will now briefly introduce in order of their speech in this panel. So first, we are going to have Major John Legg, who serves as an assistant professor of law at the United States Air Force Academy, where he is chief of academics and course director for national security law. Major Legg received his LLM in national security and US foreign relations law with highest honors from the George Washington University Law School, where he was a national security fellow at the US Department of Justice National Security Division. He earned his GD magna cum laude from Regent University School of Law in 2008. Then we are going to have Lauren Voss, who is the Senior Advisor for Civilian Harm Mitigation at the Defense Security Cooperation Agency. She's a former Air Force officer with US and NATO deployments. Lauren researched and wrote on national security as a Harvard traveling fellow in Israel and Palestine. She also spent time in Ukraine along the conflict line conducting interviews on the effects of explosive weapons on civilian healthcare. Then we are going to have Nick Mull, who is the Civilian Harm Mitigation Program Manager for the Defense Institute of International Legal Studies, otherwise simply known as DIILS, which is the lead security cooperation resource for legal engagement for the US Department of Defense. In that role, he focuses on the advancement of civilian harm mitigation through long-term institutional capacity building programs with partners nations, providing advisory and consultation services. So let us then start with our first remarks by John. John, as a judge advocate, what is your perspective on advising commanders in support of avoiding civilian casualties in partner operations? John, you need to put your mic on.
Thanks for that. Thank you, Anissa, for that question and the reminder about the technology here. And also I want to thank the American Society of International Law and the Libre Society, as well as many other excellent organizations and individuals participating in this series. I'm humbled to participate today and share the screen, so to speak, with the distinguished panelists here. Let me begin by presenting the standard disclaimer that the views that I express are my own and do not necessarily reflect those of the US government, the Department of Defense, the Air Force, or the US Air Force Academy. In my brief introductory remarks, I think what I want to highlight, which is responsive to Anissa's question, is the American military's strong commitment to the internalization of international law of war principles at all levels of command and across career fields, specifically in support of the shared goal of minimizing civilian casualties to the maximum extent possible. I think that the willingness of the American military to permit its members to contribute to a conference such as this, as evidenced by Lieutenant General PD's remarks earlier in this series, reflect the commitment of the institution to the cultural internalization of LOAC principles. As an educator presently at the Air Force Academy and a past command legal advisor to both a Joint Special Operations Commander and an Air Expeditionary Wing commander, let me just say that I've personally experienced that cultural commitment to internalization. At the educational level, let me just say that the future commanders of the American military very early in their education are presented with the goal, the moral goal and obligation, as well as the legal obligation to mitigate civilian harm. And that's something that's presented to every single cadet who graduates from the United States Air Force Academy in their Law for Air Force Officers course, and even at a more advanced level in further study. But every single graduate of the United States Air Force Academy, and then also every single commissioned officer who subsequently serves in all branches, receives instruction on this goal and legal obligation of minimizing civilian casualties. So when a judge advocate advises a commander on civilian harm, they are talking to an audience that has already been pre-culturalized, so to speak, on this goal and legal obligation, both from a moral and a legal perspective. And I think that that keys in with several of Randy Bagwell's comments on the potential cons of partnered operations, because I think most of those get at the issue of internalization and culture. So factors such as differences in cultural values, lack of training and education, and willingness of other groups to accept civilian harm to advance their cause. These are all cultural and internalization issues that I think the American military, by the way that it educates and fights, has set up structures to reduce these negative aspects of partnered operations. Doesn't mean it's perfect, doesn't mean that there aren't rules or ways that this could be improved, but the fact that at a very young age, every officer who commissions into the United States military gets instruction on compliance with the law of war, international humanitarian law, specifically with respect to distinction and proportionality, starts off that internalization of a institutional as well as a personal commitment. And I think that the way that this feeds into partnered operations is the reality that it's going to be officers and enlisted members at the tactical level working with these partnered operations that are interfacing with them. And so if that commitment to internalization of LOAC principles is held at the institutional level, then it should reflect in those individual interactions at the partnered tactical level, whether you're talking about advise, assist, or accompany missions, to the extent that American military are reflecting the institution's commitment to minimization of civilian casualties. We're doing our utmost to get after that issue of civilian harm and addressing the cultural disconnect that potentially can appear in partnered operations. So in addition to the national political level rules such as Leahy vetting or things that perhaps my other colleagues on the panel have more experience with conducting, that individual interaction at the partnered level, at the tactical level, I think is the beginning of where you have to internalize this commitment to reduction of civilian harm. So judge advocates play a critical role in that, in briefing American military troops who will be participating in partnered operations, and re-emphasizing that institutional and cultural commitment to the law of armed conflict. So with that introduction, I look forward to what my other panelists have to say, and thank you for the opportunity.
Excellent. Thank you very much, John, for having set the general framework of the discussion. Now, perhaps, Lauren, I will turn to you to help us understand a bit the scene, you know, the space where we are talking now. So, how does the U.S. in fact define what is a partnered operation?
Thanks. Happy to be here today. So it's actually an interesting conversation because the US doesn't frequently use the term partnered operations, or if it does, not really in the way that the ICRC and a lot of international bodies tend to. So, you know, a lot of people say partnered operations, they tend to think of coalition operations fighting hand in hand. But the US actually gives it a much broader interpretation. And what you'll hear us frequently refer to is something called the by, with, and through operational approach. And the meaning of that has actually changed over time, which is fascinating if anyone wants to read about, you know, how much it's changed from what it originally was. But today, General Votel back in 2018 defined it as operations that are led by our partners, which can include state or non-state actors, with enabling support from the United States or US-led coalitions, and through US authorities and partner agreements. So it's more of one type of thing versus an option like it used to be. And so that can range anything from, say, you know, us selling munitions or even munition parts to a foreign country, to working side by side in a coalition. At the Defense Security Cooperation Agency, where I currently work, we do a range of activities from arms sales to training to institutional capacity building. The one thing that we don't do is support that, you know, fighting side by side element that Major Legge talked about in detail. So, and underneath that kind of by, with, and through, there's two main authorities or two main groups of authorities that I think it's important to cover. It's called Title 10 and Title 22. And those are just, you know, the short terms for where they fall in the US code. So we frequently talk about arms sales or Title 22. And what that means, there's two groups underneath that. Foreign military sales, which is when a country would use its own money to purchase arms, training, equipment from the US. Or there's foreign military financing, which is actually the US government providing the money for that country to then go and determine what arms, equipment, or training that they need, but using US money. So how does the US think about arms sales is actually a little bit different than a lot of other countries, in that arms sales and defense trade, generally speaking, are actually implements of foreign policy. And that is important because it has two implications of that. One is that it's kind of all arms sales and defense trade is looked at as a totality of circumstances. So the United States considers a lot of different things that you wouldn't necessarily think when approving these sales. So everything from, you know, political, military, economic, arms controls, human rights concerns, all of that is figured into whether or not, you know, they will provide military equipment in a certain circumstance. The second implication of that is actually that the lead for all of these efforts is not the Department of Defense. It's actually the Department of State, because it's considered foreign policy. So it's actually the State Department that oversees all of this, although the DoD is heavily involved. So for the first one, talking about what that means for foreign policy and looking at all of these different factors, it actually means we look at everything ranging from how the partner will use these arms to impacts for regional stability in our relationships with the other countries in the regions, the contributions to US security and foreign policy. And of note to today's conversation, we explicitly do assessments on the country's ability to operate in a manner that reduces civilian casualties. And we actually have an assessment that goes further and says, okay, what additional things could be done, training, other capabilities, different capabilities to reduce that risk further. which I think is pretty unique. And some of that is new within the last couple of years that we've really explicitly called that out further and farther. So it's actually the Department of State's Office of Regional Security and Arms Transfers, which is known as RSAT, who oversees all of this in close partnership with the Defense Security Cooperation Agency and the Geographic Combatant Commands. But I would also be remiss to leave out Congress. So here in the United States, Congress also has a role. They frequently require congressional notification in advance of an arms sale actually being finalized. And they can, if they so choose, take formal action to stop that arms sale from going forward. So as I said, there's a couple different ways this can happen. The transfer of munitions can happen through the Title 22 I just talked about. We also have something called Title 10, which is security cooperation programs. And so that all happens through authorizations and appropriations that are done by the Secretary of Defense in the NDAA. So that's the National Defense Authorization and Appropriations Act. It's just our yearly appropriations and authorizations for defense. And what we mainly talk about in that bucket is something called Section 333, which is a train and equip program. And what happens there is the goal is to actually build the capability of a partner to conduct a specific type of operation. So it can be counterterrorism, ISR, border security. And so sometimes that includes munitions, but not always. It might just include training, equipment, and always has an institutional capacity building element. So we actually have quite a wide range of tools that we can use here. Specific to today's conversation, there was really a game changer around partnered operations and civilian casualty mitigation in 2018. And what that was the conventional arms transfer policy. Every president releases one of these, but the 2018 one, for the first time, had language that said it was the policy of the executive branch to facilitate ally and partner efforts to reduce the risk of national or coalition operations causing civilian harm. That was new. That gave us the impetus to start a lot of new things, including my role and my team at DSCA. I would be remiss not to mention, though, that the conventional arms transfer policy for many previous iterations had other lines in it that are relevant to today that are still in the current version. So specifically in Section 3D on decisions, we are required not to approve any arms transfer if there is actual knowledge the arms would be used for genocide, crimes against humanity, violations of Common Article 3, et cetera, et cetera. So any of those, you automatically cannot approve those transfer. And then two, that we consider the risk that the transfer contribute to violations of IHL, human rights law, mass atrocities, those types of things. So those have been part of it for a long time. We also had an executive order that's actually from 2016 under President Obama, 13732, if anyone wants to Google that later, which encouraged us to engage with foreign partners to share and learn best practices for reducing the likelihood of and responding to civilian harm. And that was reaffirmed by President Trump in 2018. So that's still a good guidance for us. But really that conventional arms transfer policy was what started it all, or started these new efforts to really focus on this when it comes to partnered operations. So over the last 2 years, Department of Defense, in coordination with the Department of State, has been really busy working on these, on different efforts. So I'll let Nick Mull, who is one of the other panelists, talk to the training aspect of it. There's a couple other things that we've really focused on. One thing I'll say up front is, we look at the law as one component, but we've really been branching out and saying, if you want partnered operations to reduce the risk of civilian harm, there's so many other components that go back into it. And I think these are some of the things that both Randy and Major Legg covered, were about, talking about their actual capability to use those munitions, what skill levels they have, how they know to do targeting, how they know to do collateral damage estimation. So all of those operational doctrine and processes, the personnel and skills, like all of that should be part of the analysis process, which makes you take a step back and look at it from higher up and say, how do all of these pieces fit together? So we did a couple things. One of them was really looking at system-specific capabilities, and that was working to provide partners enhanced tools and training so that they can better use US origin munitions. So we actually led a working group of experts on targeting and worked through releasability and process issues so that we could share more of what we already have, both tools and methodology and processes with more countries. So we released a new policy that actually states that with the transfer of certain munitions and delivery systems, we have a requirement that we have to account for targeting capabilities and how the country does targeting. Of note, as Randy mentioned, the collateral damage estimation, how partners do that, making sure they have a capability, and if not, how we can ensure that they have one. One of our other lines of effort was around advisory programs, realizing, as we've talked about, that these countries range in capabilities, in culture, and missions that they complete. But there's some reoccurring themes that tend to pop up here, right? And so knowing, what those themes are and determining when we have advisors, how they can assess what themes are most relevant to the partner they're working with, what best practices they should help advise on, and then most importantly, how they help the partner integrate that into their processes that are already in place. Which is just extremely important to make sure that things stick when they happen. So we've been working on things like helping countries develop and use no strike lists, which is actually a quite complicated topic to keep updated and integrate into your operations. We talked about civilian casualty tracking cells and the data analytics that goes into that, and especially the lessons learned that you can put back in the operational circle so that okay, here's what we're going to do different next time. And so we have a whole range of topics we're working on. COVID hit, so we've been doing some virtual engagements, but we haven't had a chance to actually pilot and roll these out with countries in person. But our virtual ones have gone well. We had a general sitting in his car, zooming and talking. So everyone's been making it work so far. The last thing I'll quickly say is one of the things that we've been working on is enhancing our risk framework. So as I said before, we're realizing that there's so many different elements that go into risk and mitigating it. So trying to expand the way that we look at that in a really systematic way to say, here's the different categories we look at, where does the country fall, and what are the specific things we can do to mitigate that risk. So when appropriate, that could actually say, when working with this partner, we want to provide different things, we want to do different kinds of training, or we want to provide supplemental capabilities. So I'll stop there, but that's kind of a summary of how the US looks at partnered operations.
Excellent, Lauren. I have already a couple of questions for you, but I will leave that for after. So now, Nicholas, I would like to know a bit more about the mission and role of the DILS in this regard. Could you please tell us a bit more about what you do?
Absolutely. So, as everyone else mentioned, thank you to ASIL and our sponsors for having us here. And I'll, of course, thank Colonel Bagwell up front for his shout out to DILS in his opening remarks as well. And as you can see with us, our former uniformed military personnel in the U.S., we still match and we still decide to wear a uniform anyway as civilians. So I appreciate being here. And as Major Lake said, and as any common thing in dealing with a U.S. government employee, I must immediately disclaim that any statements and opinions that I make should not be attributed as a representation of official statements and opinions of the U.S. government, Department of Defense, DSCA, or DILS. So please only attribute them to me as an individual. All right. So, and again, I'm from the Defense Institute of International Legal Studies, more commonly just known as DILS, to our partners and within the U.S. government. We are on LinkedIn now, if anyone's interested in following. We are one of the security cooperation enterprises implementing components that fall under the Defense Security Cooperation Agency that Lauren already spoke about generally. So DILS is the lead security cooperation resource of the U.S. government for professional legal engagement. with defense and security sector institutions of partner nations. And I will use the term partner nations over and over again, which should reflect a little bit about what Lauren was talking about, how the very broad aspects that we view partners. And it will help, I guess, come to a greater understanding through my remarks, how that actually helps mitigate the risks that are normally associated with coalition operations. So our primary mission is to strengthen institutional legal capacity of partner nations through activities that promote the rule of law, accountable defense and military institutions, civilian control of the military, democratic governance, and achieving optimal compliance with international humanitarian and human rights law during the conduct of military or security operations. So in a non-COVID environment, DILS typically engages with more than 50 countries annually across the globe through 4 primary programs. One is our multi-year institutional capacity building programs with ministries of defense or other ministries with defense or security sector oversight and military service level headquarters. 2 is our resident courses here at our education facility at Newport, Rhode Island, that provide more in-depth substantive legal education and training, and also seek to improve opinions and attitudes towards laws applicable to military and security organizations. 3 is our mobile education and training missions that in the future largely are going to be more related to civilian harm mitigation, specifically associated with the conventional arms transfer policy that Lauren noted, or the other statutory authorities that she indicated, which more look towards how do we operationalize the law in a better fashion to further internalize, but provide operational processes and decisional tools for those non-lawyers and for greater formalization and predictability of action. And 4 is our statutory mandated law of armed conflict, human rights, and rule of law seminars for partner nation units that receive grant assistance under statutory authority 333 that Lauren mentioned from the US in the form of military equipment or military training. So our main effort currently, is our multi-year institutional legal capacity building programs. And we also generally seek to synchronize resident courses and other substantive training to complement and supplement the work to initiate institutional level reforms at the ministerial and service headquarters level that permeate down through the tactical level. For our partners, we try to bring outside perspectives, support, expertise, and experience in the particular areas sought for capacity building, such as IHL or IHRL, to provide advisory and consultation to our partners, especially those that are the leading agents of change in their states that seek transformation and improvement. Now, I should highlight specifically that our work is not limited to IHL or IHRL, but also includes wider legal capability areas like, based on domains such as our maritime programs, or governance such as combating corruption and ethics, or just generally supporting the professionalization of military forces. But for our purposes and my own area of work, I'll focus upon IHL and the relevance of this session. So from our relevance, institutional legal capacity, can be thought of as the enduring capacity of a state to conduct military and security operations while achieving optimal compliance with domestic and international legal obligations at the strategic, operational, and tactical levels. So now, how does this all serve to support the mitigation of civilian harm in coalition or partnered operations, as it's termed for the session? Our work can be associated with what we call phase 0 of joint operations, that is shaping activities. And that through our work, we build and sustain working relationships with partners based upon mutual respect. We build a shared knowledge and understanding of the importance of IHL, IHRL, and rule of law generally, and the principle of doing everything feasible to mitigate civilian harm in military and security operations. We developed that understanding of IHL as a strategic capability of a military force that mitigates the risk of tactical decisions that compromise strategy, that helps ensure that phase 2 and 3 activities of joint operations of seizing initiative and accomplishing military objectives preserve the conditions necessary for peace to take root in the event, in the end of a conflict, and in phase 4 of stability operations, and phase 5 of enabling civil authorities, thus being one of the greatest force multipliers for long-term strategic success of a military or state in general. We also share lessons learned and best practices for the building, sustainment, and employment of an institutional legal capability that prioritizes and integrates the law into all defense management processes, planning at all levels, and internalizing the normative objectives of IHL and IHRL as applicable. And we also assist partner nations in developing custom-tailored plans for the building of, or improvement or modernization of, institutional legal capacity, in which we would provide the advice and consultation over multi-year periods to implement that plan, of which we both have believed will lead to the sought-out change. So we're talking about a long front-end partnership before we have the need of going and conducting operations together, to ensure that common operational picture, common developing and sharing of normative values, and how we operate in warfare. Now, from an operational law perspective, the resulting effect is that we as DILs, like I said, are at the front end process to mitigate risk to civilians in likely or potential future partnered or coalition operations. And that it ensures that we are both us and our partners are partnering with professional military forces dedicated to the rule of law, along with legal, moral, and honor obligations to protect civilians and mitigate the likely occurrence of harms to civilians from our own operations. So, in the interest of time and suppressing my lawyerly desires to just keep on speaking, I'll stop there, but look forward to further discussion and any questions. Thank you.
Okay, thank you very much for that, Nicholas. Since we have a little bit of time, perhaps I will start by asking each of you a question, and then open the Q&A session, perhaps in 10 minutes time. The first question would go to Major Legg. Could you tell us about perhaps a challenge that you have encountered in your operation work with regard to, to partner operation? What could you tell us more about an experience that you had to face?
Sure. Thank you for that question. So just over a couple deployments that I have experienced, and I'll have to speak kind of at a level of generality, considering classification requirements and that sort of thing. But I think that there's sort of a fog of war or information challenge that that is an experience in coalition or partnered operations. So, the challenge of, the US government knowing what the coalition partner is engaged in and being able to respond in real time. And then just the general challenge of just bureaucracy of the appropriate authority having the ability to act. And I'll just say that, it seems like there's a trend in giving commanders discretion. And, I personally would advocate that the lower the level of approval authority for the commander to respond is a way that we frequently can mitigate civilian harm. And so one example I can think of in my first deployment in the CENTCOM area is just participating in what are called information operations or military information support operations, also known as information warfare operations, but depending on how doctrine develops, but just cooperating with our local partners, specifically through communicating to civilian populations to remove themselves from areas that might be the focus of a partnered operation. And sometimes because of military necessity, there's a narrow time window for when that communication can take place. But I've seen in several examples where when US military commanders knew about a coalition partners operation, knew about the risk to civilian harm, then they were able, if they had the appropriate authority, to act quickly to notify civilian populations through various means. I mean, leaflet drops, etc., to avoid certain areas. And so when you're working with a coalition partner, the challenge can be coordinating that information and then ensuring that the appropriate official who has the ability to act has the authority to act in that situation. So.
Excellent. Thank you very much. No, it helped us also to contextualize a bit the discussion. So it been very useful examples. Thank you very much, John. Lauren, I'm turning to you now. You mentioned that the US has kind of a broader, let's say, in definition of what could be a partner operation. And you mentioned also that it could also include, partnership, I put this in bracket, from with armed non-state actors. And I was wondering whether in your work in, for example, sharing lessons learned, do you also include armed non-state actors, or is it just with regard to let's say, stricter partnership with states, or do you also include armed non-state actors in this in the discussion that you have on lessons learned, for example, or on the issue of arms sale?
Yeah, that's a great question. First, let me offer the same caveat that my colleagues did that I always forget to, which is that I'm speaking in my personal capacity. I always forget. So on that point, I would say that specifically my agency does conduct some arms sales that are to non-state actors. I assume that the people listening could guess who some of those non-state actors are. I unfortunately can't comment on specific transfers. When it comes to, though, any of the relationship building or lessons learned, that tends to not happen through my organization and more frequently would occur through either the geographic combatant commands or potentially the special operations command through there is to more on the operational side of pairing up with those units. When it comes to the arms transfer side of the house, when doing our analysis, though, for what risk there might be, the analysis is actually quite similar, because when you look at non-state armed groups, you actually have such a range that it can be, some of them can actually be more professionalized and organized than some state militaries. And so the range can actually be comparable. So the analysis that we do when looking at the risk in civilian harm is actually similar. The one thing that I would flag that I personally think is something that makes it more difficult is when it comes to sharing any type of classified information or classified technology. When it comes to non-state actors, they just don't have the ability to protect that information in the same kind of way that a lot of states would. And unfortunately, when it comes to a lot of these types of conflict, intelligence, more advanced weapons all tend to be classified. So I'd say that's the one bigger issue that we face when it comes to non-state actors.
Nissa, you are on mute. We cannot hear you.
Sorry, thank you for the reminder. I'm caught this one this time. So Nicholas, I'm turning to you now to ask you, how do you deal with different interpretations of the applicable law? For example, different interpretation of the scope of application of AP2, or different, interpretation of what Common Article 1 would entail, and so on and so forth. How do you deal with your partners? How do you share or discuss your own interpretation with them?
This is a good question because obviously, when we're talking about having mutual respect for our partners and having, forming that true partnership is, an understanding that each is representative of our own sovereign states that may have exercised that sovereignty to, incur greater international legal obligations through various instruments like AP1 or AP2, as you mentioned. Or it may come down to different state interpretations of law that we may fundamentally agree that we are both accountable to, but simply just have a different interpretation, as to that. So, this is really, a fundamental element towards building our partnerships, from that early front end stage. But it's also a fundamental element towards actually being able to operate as a coalition if needed in future operations. Because, we need to ensure that, in that mutual relationship that we're not putting each other at strategic risk. And by that, I mean, we must understand how the actions of, and I will use very generalities here, so that way I'm not officially speaking for any government, but, we must understand how the actions of partner A may impact the political, legal, and moral legitimacy of partner B, whether that be with their own domestic population, or that may be more or less tolerant to potential legal violations, or even if not violations of the law to the extent of war crimes, but a lesser achievement of the ultimate goals of IHL with mitigating suffering, and as far as we really actually exercising our full capabilities to achieve that realization, or are we only seeking to not commit a war crime? And also is the world community at large, is understanding that partners need to recognize the potential impacts to long-term reputational concerns, or even different legal accountability mechanisms that partners may be subject to the jurisdiction of, such as, a regional human rights court, the International Criminal Court, or their own domestic courts, of which there may be a certain level of accountability based on those different legal obligations. And how it may also impact the relationships that partner B might have with partner C, with country C, D, and E. So we all have strategic concerns, and as Colonel Bagwell mentioned, we all have national interests that exist beyond the partnership of conducting a particular military operation. And if partners don't have the common understanding of those different legal interpretations or legal obligations, then partner A may in fact undermine the extraneous national interest of partner B. Especially like when you look at a country like United States or other very large countries that may have national interests that really are very global and permeate throughout all the different regions versus partners that may only have regional interests. This can be a particular issue. So it not only can risk the future relationship between these two partners, but it can also jeopardize the ability of each to continue in the particular partnered operation that we are talking about. And as a result, they fail to achieve the strategic objective associated with it. So, part of the shaping aspects of our work is building these common understandings. We recognize that our partners may not have the same, legal obligations or interpretations as the United States, and that awareness of them, of these distinctions, will ultimately facilitate smoother partnered operations in the future. It supports the development of coalition rules of engagement and helps ensure that national caveats that may restrict the means and methods of one partner, aren't a shock to the entire system when we have to go and we have an immediate need for a military operation. Through our enduring relationships as DILs, for example, we learn of these things well in advance. They learn of our actions and the way we do things well in advance. So when conducting key leader engagements and other activities associated with institutional capacity building, for example, we acknowledge and discuss these issues, with that mutual respect. And, one of the first, it is one of the first steps in our capacity building work. Now, in our like educational activities, such as our resident courses and mobile training missions, we present curriculum that, where appropriate, will indicate the views of the United States, and will honestly assess, the the weight of that opinion in the world community, as well as other competing views, that may come into play. So, we respect the potential differences and decisions of states to, incur those different obligations. And, beyond simply stating different opinions, we try to discuss the underlying rationale or legal theories or cultural perspectives that may lead to these different conclusions. Again, so we have a greater shared understanding. We compare and contrast discussions related to actual treaty obligations, such that we discuss relevant international legal instruments, whether or not the U.S. is a state party. For example, our curriculum that we are working with will always account for AP1 or AP2, because the reality that we have to live with is that the vast majority of our partners are states party to AP1 and AP2. And doing otherwise would be an injustice to them, and really an injustice to us as well, because it would jeopardize our future ability to rely on them in military operations. We also outline, if we have like country specific training, if the United States, we're running an engagement with country B, we will, when we discuss treaties, we will discuss with them, US is a state party, your country is a state party, and vice versa throughout, as a comparative and contrast to build that common knowledge. Because, the reality is that we live, in a world in which military operations are rarely going to be unilateral. Yet states will always have different legal obligations or legal interpretations to a certain degree. We need to account for this friction point as early as possible, so that we can think about how to mitigate this risk. I guess an important aspect to just know is that even for us, whether we're lawyers or operators in those military forces, we have to know these things, because we have to know what we can and cannot rely on our partners to do, in accordance with their legal obligations. But is that, at this point, when we're talking about IHL, for example, or even the relationship of IHL and IHRL, as a legal advisor, you have to know not just your country's laws, but the laws of all of your partners, or you're going to fail to be a successful legal advisor. So, I hope that helps paint the picture of how we try to get this, start dealing with this issue as far as on the front end as possible.
Excellent. Yes, thank you very much for that. Since I don't see any Q&R in this conversation, perhaps I would like to give you the opportunity to have one final word for each of you, including Randy, if you want to intervene, on from your perspective, what you think has worked, and what do you think can be improved with regard to the protection of civilians in partner operations? So, Randy, would you like to say something, or as you wish?
I hate to say I wasn't completely paying attention, but I caught there was a question in the chat that I wanted to look at. And we had it looks like something that both Nicholas and I referred to. So the roots of restraint by the ICRC study, and the also deals on legal and moral obligations. And also he mentioned honor. So I'll let Nicholas talk about that a little bit, because that is in the DoD Law War Manual as kind of another principle of IHL. But the roots of restraint, I commend that. It's a great report by the ICRC, where they looked at 4 different categories of fighters and what motivates those fighters to comply. And I don't think we have time to get into it greatly here, but I will say that it does look at, again, something like a central controlled military like the United States, all the way down to like kind of ad hoc groups in a village that might come together to protect. So I think if you it's a short study, please go look at it, and I'll leave the other one to Nicholas.
Okay, great. Yes, we'll go to Nicholas in a minute with the question that was just asked now in the Q&R. But perhaps John and Lauren, would you want to say a final word with regard with what has worked and what can be improved from your perspective in this topic?
Sure, I'll go ahead. I think that I'll just end with the thought of the importance of culture and seeing ourselves as co-laborers in many respects with so many partners in this area of reducing civilian harm. So, it takes the participation and cooperation, not just of the US government, but NGOs, partner states, and coalition members all committed to this goal of reducing civilian harm. And so if we have a culture of seeing each other as co-laborers rather than adversaries, that's certainly easier to do. And it's especially, recently, it seems like, the US government has certainly made attempts to increase its transparency with the amount of information it gives in its annual civilian casualties report. And I think that shows the US government's commitment as a cultural matter to see itself as a co-laborer in this goal. With that said, thanks to all the panelists and to this opportunity today.
Thank you very much, John. Lauren?
Yeah, I would say sometimes it's almost easier to say some of the things that we know haven't worked. Is a little bit easier to start with. So I would just foot stomp what Nick said about doing more upfront, and that by the time you are fighting side by side in a coalition, it can often be too late to work out some of these differences on your interpretations of the law, what obligations you have, your different processes and rules of engagement that you apply. So doing more upfront has really been, something that we are trying to do. Dills does an amazing job, but I would argue it's something we could always do more of. But I think the main takeaway for me is really trying to understand different countries and different partners' motivations. Talking to them about interoperability is usually key. We had a conversation now that a lot of the conflicts in the future are going to be partnered operations. And so for countries that have smaller militaries or have a lot of security concerns, talking to them about how working on these issues helps with interoperability is usually a great way to start the conversation. I would also say, the recognition that this is just a hard issue across the board. And so conversations where we also talk through, what the US has struggled with and some of the challenges we've faced, I think really helps the conversation. The US has gotten good at this because we've been fighting wars for over 20 years. And not every other partner has that same level of experience. But some of the issues that we face when looking at accusations of civilian harm from 8 years ago, we face the same issues that other partners might do in those situations of collecting information, trying to really figure out what happened. And so that recognition, I think, goes a long way. The other thing I would say is, I know this is a legal forum, but I would advocate that you don't just make it about the law. And I think that goes to the question that was asked. But in general, the law of armed conflict can be somewhat permissive in some circumstances. And the United States puts a lot of policy obligations on top of that. And encouraging partners to do that and take all of the measures that they can, I think it goes a long way. I also think it just helps with conversations. It's actually quite complicated to know whether or not a law of war violation occurred, especially if it's not your military and it's another country. Knowing what information they had at the time, what kind of decisions they made, is very difficult. And generally, obviously, when talking to a foreign country about this, anything that might seem like you were accusing them of war crimes tends to make the conversation go a little cold. So obviously there are times and places for that, but initially when starting those conversations, talking more about the professionalization of forces, what responsibilities we have today, our ethical and moral obligations, allows you to have, I think, a more robust conversation. And then finally, I would say, quite honestly, for some countries, the political pressure does matter. The international community bringing attention to these issues, NGOs bringing attention to these issues, and highlighting specific instances. I have seen that as a driver of action in some cases. So I know that was a lot of different things, but I think it really comes down to understanding the motivations of different countries and realizing that it varies.
Excellent, Lauren. And perhaps also following your thoughts, now I have the final question for Nicholas, which is asked by Mark Linning from Civic about what Randy talked, the roots of restraint in war. And you mentioned the efforts by deals that were not only linked to legal and moral compliance obligations for better civilian harm mitigation, but also honor obligations. And could you please elaborate a bit more, and this is Mark asking you, on that honor obligations and how it can strengthen also law compliance and how this effort by deals can look in practice? Thank you very much.
Thank you, and thanks for the question. I know we're fighting Cinderella's time with a magical cutoff of the webinar. So ahead of a fuller explanation, I will a note from Mark or others that are interested in it. And again, personal, not disclaimer, but I did publish a paper in 2017 that you can find online on my SSRM page entitled The Honor of War, Core Value of the Warrior Ethos and Foundational Principle of the Law of Armed Conflict. And you can find that for a fuller, greater explanation of it. And then, of course, I appreciate the ICRC Roots of Restraint and War study because I found that it validated my previous work. So that's always beneficial. When we're looking at that is when we're talking about, developing institutional legal capacity, for example, it's like in any other development type of work, we have to understand that simply knowing something doesn't shape conduct. And even knowing and changing individual attitudes does not necessarily shape conduct. We have to understand as a greater society and understand that militaries quite often, just as they are in the United States, are a subset culture of the civil society. You'll find that there are very distinct cultural norms in the U.S. military, as you can see from the background from the U.S. Marine Corps, that just are very different than American civil society. And looking at that, we have to understand how societies and organizations and cultures make decisions, but also what social norms do they value? Coming from, maybe a Western perspective, there may be like this, or even really coming from the perspective of lawyers, as lawyers think to themselves, well, we taught them the law. Well, that's all that's needed because they have the right law and they know what the law is now and they understand it. So they'll comply because it's the law. But the reality is that's not how decisions are made, and that's not how conduct is shaped. And so we have to, identify other social norms that may exist in a country that we might be working with, so we can help them identify. All right, if you have a very strong, identifiable honor culture in your military, or you have a country and a society in which you have very strong religious roots, both of which that you can leverage to integrate the law into those same normative values, and it's about trying to paint a picture of an alignment between, what I called, in my paper is really the conceptual pillars of human civilization is law, morality, and honor, and that, learning and how to get to a point of where we align these, where they're better integrated, is the way to maximize optimal compliance, because they have different incentives and different accountability mechanisms that are associated with them that can alter and influence behavior in different ways. Now, that is not to say that we as DILs go in and we teach other people their cultures. We are identifying for them like, here's how you can leverage these existing cultural norms to maximize the internalization and the acceptance of the law of armed conflict. And that's why, with institutional capacity building, we want to get them to the point that they're training and educating their own people on the law of armed conflict, because we don't want an outsider coming in. If you think about a traditional honor culture, if an outsider, some American lawyer is coming in and telling them, here's the right behavior, there is a natural resistance to that. And so that we have to seek to build an internalization where the law is perceived as an integrated part of their own culture and not as some external restraint being thrust upon them. So, I guess in short, is that how, I'd look at that. But I very much appreciate the question, and certainly find me on LinkedIn if you want to have more conversations about it, because I really did. I just finished up our Human Rights and Law of Armed Conflict resident course, in which one of the blocks of instruction that I included in there and developed was an understanding of aspirational practice under principles and honor as a principle of the law of armed conflict. Thank you.
Excellent. Thank you very much for that, Nicholas. And I look forward to read your article as well. So that will be the end of our discussion today. Thank you very much for participating in this fascinating conversation. Be sure to stay tuned and to tune in to the next and last actually session on the Civilian Casualty Symposium series, which is entitled Accountability for Civilian Casualties. So this is going to be also a very, very interesting panel. And this panel will take place on the 18th of November, so next Wednesday at 12 p.m. Eastern Time. And you can already register now on the ASIL event calendar. So I thank you all of you very much, and I look forward to continue this conversation in a different way. So have a nice day and afternoon, and so all the best.